Please rise.
Good morning and welcome everyone to the Utah Court of Appeals. We have two matters set for oral argument this morning. The first is it Brownstein or Brownstein?
Brownstein.
Brownstein versus Brownstein, case number 2024-1029. If I could have counsel make their appearances for the record, please.
Alan Morrison on behalf of Peter Brownstein.
Good morning.
Emily Evans on behalf of Ellie Brownstein.
Good morning and welcome to you both. For the benefit of our audience, we have allocated 15 minutes for argument on each side. I see, Mr. Mortson, you have 12 minutes, so 3 reserved for rebuttal. Is that correct?
That is correct.
All right. So if we have questions that take you beyond your time and you see zeros, please feel free to answer our questions. And if we do keep you over time because we are questioning you, we will not count that against your time for rebuttal. And the same for you, Ms. Adams. If we keep you over time, please continue to answer our questions. You're both experienced advocates here, so unless you have any questions this morning. All right, we'll go ahead and begin. Mr. Mortson.
Good morning, Your Honors, and may it please the court. Under the terms of what everyone agrees is a binding and enforceable premarital agreement, Ellie agreed to waive any right or interest she would otherwise have in Peter's Fidelity 100 account. The agreement designated that account as Peter's separate property.
Is it the account globally, or is it that she agreed to waive her right to whatever was in the account at the time of the marriage?
Your Honor, both. Based on what was attached to the premarital agreement, there is a Fidelity 100 account statement.
So is it your position that whatever was put into the Fidelity account even after marriage is still protected by the prenup?
Not necessarily.
What's that mean?
Well, it means only if what was put into the account was Peter's separate property, then it remained protected by the prenup. Because even under paragraph 7, that property would be Peter's alone.
Why is? Let me.
Continue.
Sorry. Why is that so under paragraph 1 of the prenup? I'm looking at the language of paragraph 1, which is the key paragraph from your end, and it starts out by talking about separate ownership of property acquired prior to the marriage, and then in the first sentence it talks about the property that, quote, each owns at the time of marriage. So why isn't the implication of that paragraph that what's protected by the prenup is whatever was owned at the time of the marriage and in the Fidelity account at the time of the marriage?
Well, because under paragraph 1, it's not just what was owned at the time of the marriage. It also includes income therefrom. So under standard, I mean, we talked about this.
But it would be income that was linked to property that was owned at the time of the marriage.
It could be, yes.
Why would it be anything beyond that?
Well, as I said, if Peter acquired what under paragraph 7 was separate property, and he placed that separate property in the Fidelity 100 account, then that would remain protected.
What language does that?
Section 7, paragraph 7 does that. Because paragraph 7 tells us that any property acquired by the parties after marriage shall be treated as if the agreement doesn't exist.
Right, so it seems to me, and please tell me if I've got this wrong, but it seems to me that when you put paragraphs 1 and 7 together, here's what you have. Paragraph 1 covers whatever was owned at the time of the marriage and that is listed in Schedule A. And it says that's going to be covered by the prenup. Paragraph 7 says that anything that's acquired after that is going to be treated under ordinary rules without regard for the prenup, right?
Correct. But what the import of paragraph 7 is, if I receive, for example, inheritance under the prenup, that's separate property. And so if I place it in the Fidelity 100 account, then it remains protected under the prenup.
What that last part, what provision says that last part?
Well, paragraph 7.
Paragraph 7 says that you treat after acquired property as if the prenup doesn't exist.
Correct. And so
how would
I mean, in that case, what I'm trying to say, I guess, is the common law and the prenup work together to protect that separate property.
Let me go ahead and jump through my Socratic part of this thing and just ask you the question that I want to ask you, which is I can't figure out why his inheritance funds would be covered by the prenup.
Well, what ended up happening is there wasn't a separate discussion about inheritance funds
Right.
at trial.
But
But inheritance ended up being placed in the separate account.
right,
And so,
but paragraph 1, this is back to my question. Paragraph 1 says that what's covered by the prenup is, quote, separate ownership of property acquired prior to the marriage.
and
He
in-
doesn't inherit prior to the marriage, right?
correct.
So, and then it includes a Schedule A, and Schedule A defines the fidelity account as having $160,000 in value at the time of the marriage. So if he doesn't get the inheritance funds until the 2010s, why are they covered by the prenup that's signed in 1996?
Well, because they're in the Fidelity 100 account.
So let me
And-
jump in and see if I can help clarify this, because I too have some questions about the inheritance. So the inheritance is not property that's owned at the time of the marriage because he hasn't inherited it yet,
That's correct.
right? And as I understand you arguing Section 7 of the prenup is because it's acquired after the time of the marriage, nothing in the prenup affects how the common law treats an inheritance.
That's correct.
And under the common law, an inheritance is separate property, although you can argue it's been commingled right after you've received it.
Well, the only part I would disagree with is the last, because Judge Stone expressly found that it wasn't commingled. He found that the account
Well-
retained its separate identity. But everything
That's
else.
the account. I'm saying an inheritance. So under the common law, an inheritance is separate property, but you can always commingle that once you receive it, right?
You can.
if you do that. So
For
I
sure.
think the inheritance is not covered by the premarital agreement. It's covered by the common law.
That's correct.
Okay, and so then below, Judge Stone did not find that there was commingling in the Fidelity 100 account.
That's correct.
He found that the facts of the deposits of the marital related funds and that were put in the Fidelity account were a factor in finding the extraordinary circumstances exception.
That is correct.
Okay, so I will say I looked at Judge Stone's order and the one from Judge Stormont afterward, and I do want to make sure, and I'll ask Ms. Adams, is that everyone's on the same page that Judge Stone did not find commingling, because I think the language of his order is a little unclear on that, but the parties are all in agreement that he found not commingling, but extraordinary circumstances
Well-
informed by the commingling.
That is correct.
Okay.
In our opening brief, I was worried about the risk of confusion because I do think he's not very careful analytically in trying to divide. But I think fairly read, and Judge Stormont confirmed this in his order, he did not rely on commingling to find the Fidelity 0100 account marital property. And so the only basis for that would be extraordinary circumstances.
So when I can't remember if it was Judge Stone or Judge Stormont, one of them said they thought commingling was relevant to the extraordinary circumstances.
Yeah, they essentially both did.
So, this is back to Judge Oliver's question. It kind of feels like they were having it a little bit both ways. It's a little too
Well-
pejorative, but they were using commingling, but not completely.
See,
right?
and that's where I called it an
Yeah.
unusual mosaic or amalgam of equitable distribution law, because no one's ever done this, as far as I've read it, where they have expressly said that the account maintained its separate identity, but I'm still going to rely on these occasional and what we consider to be minimal deposits of marital income to find the plus or more factor to overcome any concern about extraordinary circumstances. And we just don't, sorry, Your
I
Honor.
was just gonna say, can I ask just a clarifying question, factual question? I couldn't quite understand this from either order. So Judge Stone said, no, not commingling, but commingling is relevant to an extraordinary circumstance that, because of the facts of this case, I'm gonna order that she share in half of this account, right? Did that include the inheritance amount?
Well, it necessarily had to,
It had
because he
to,
had
right?
placed the inheritance in what everyone agreed was his separate account.
So
And so-
Miss Brownstein also got half of his inheritance.
Correct.
Okay.
Under the logic of the opinion. The only thing I would qualify just a little bit about that discussion is the way it was presented to Judge Stone and the theory that he embraced initially extraordinary circumstances on was this idea that Ellie was the primary breadwinner, and the fact that her income paid for most of the family expenses allowed Peter to enhance the value of his account. And we take issue with the premise of that because it's undisputed that part of his money was used to pay for the family's expenses. But more importantly, Lindsay, Jensen, a number of other cases make clear that's not the kind of setup that allows for a finding of extraordinary circumstances given the give and take between spouses that arises.
So in this case, what do you see was the more that's required for extraordinary circumstances that was identified below by either Judge Stone or Judge Stormont? Because
Well-
I've kind of struggled reading through their orders to see what exactly it is that was the more. And I'm wondering if it was the commingling that essentially became the more that's required.
Well, Judge Stone, I don't think, considered the commingling the more. And again, I've read his order a number of times trying to understand exactly what his approach was, but I genuinely believe that his thinking was that Ellie did a lot of the work and that her expenses paid for it, which allowed Peter to enhance his account. I do think Judge Stormont, in his order, kind of tweaked the theoretical foundation and said, no, I think what he was doing was taking into account whatever limited amount of commingling there was and using that as the plus factor. And the problem we see with that approach to extraordinary circumstances is it basically comes in and says, no, that whatever happened here with marital income was insufficient to change the character of the account in order to make it marital. And yet I'm going to rely on this factual foundation that no court has recognized as sufficient to satisfy extraordinary circumstances and combine that with inadequate commingling to somehow create the extraordinary circumstances that justifies giving, half that account to the other spouse. And we just don't see any support in any of this court's case law, any of the Supreme Court's case law for that approach to extraordinary circumstances and commingling. And especially given Judge Stone's finding on page 596 of the record, twice saying the testimony and evidence that's come before me suggests that these folks did treat this as separate. And so at that point, it just devolves back into, well, Ellie was the primary breadwinner, and so we're going to treat the account as marital. And we just don't think that can stand up on review.
Can I ask you two questions about that? The first is sort of a policy question, right? In the sense of, doesn't this, if we agree with you and we agree that that's what the law says, doesn't that promote both inequity and it encourages people to hide assets or to really make sure that I'm going to get my property and it's separate and, not deal in good faith with their spouse?
I would be more inclined to agree with that concern. I think it's a valid concern, let me be clear. On these facts, I don't think it's as valid, mostly because there's no evidence that that's what Peter had in mind. I mean, if you read my friend's brief, it makes it sound a lot more nefarious than Judge Stone thought it. I mean, he said, and Peter's testimony was this was occasional and mistaken to the extent it happened. And he agreed, Judge Stone agreed, that they treated it as separate. And so if you had a situation where a court was able to reach the conclusion, hey, it looks like what was happening here was they were trying to manipulate the game, essentially. That's also a really risky game to play because you're risking the possibility of a direct finding of commingling, that the account lost its separate identity as a result of you doing that. And so the combination of no ill intent and the backstop of commingling, if it is as aggressive as I think your question suggests, at least gives me some comfort that you're not going to have that kind of bad faith squirreling away of income. And as we've said, I mean, we thought under the contract what the court should have done was to say, okay, to the extent there was marital income deposited into the Fidelity 100 account, Ellie is entitled to her share of that number. And not that, but she's not entitled to his inheritance, and she's not entitled to the prior property plus income thereon.
But not to bring this full circle, although I think I'm about to.
Well,
Even by acknowledging that the marital funds that were put into the Fidelity account, by acknowledging that could be divided pursuant to the common law doctrines, to the equitable doctrines, I think what the import of that is that you're agreeing that just because something was put into the Fidelity account doesn't necessarily mean that it's not subject to division under the equitable doctrines, right?
well,
It's not a black box that the moment you put something in, it's now covered by the prenup automatically.
no, I agree with that.
Okay.
And I think that that's even what the prenup would say.
Yeah.
Like, I wouldn't say that Peter could just take marital income
Put it into
and
the
put it
Fidelity.
in and say, hey, it's over.
Yeah.
And I would encourage the court, we don't have a lot of on-point Utah case law. Witowski out of Florida and Wilson out of Tennessee, I find to be exactly on point with what the court should have done here.
Can I ask you a question? I know we're over time, but the initial question is, as it's been framed by the briefing, the initial legal question is, can the equitable doctrines even sort of invade a prenup, right?
Yeah.
And I take your point that there's a statute that covers the grounds by which you can get around a prenup. But as I'm sitting there, this question's coming, but as I'm sitting there thinking through the various equitable doctrines and the various legal doctrines that apply to contracts, one of them that comes up, and this comes up in the briefing, is unconscionability. And I think the import of your position would be that a court would not be empowered to determine that a provision in a prenup was unconscionable. Am I overstating things, or is that your position?
No, I disagree with that.
Okay, tell me why that's
The
different.
reason is because as I read the act, it is essentially telling everyone that premarital agreements are contracts.
Yeah.
And so it identifies at the front end the bases on which you can invalidate a contract. I mean, let me put it this way. I would be in a much more difficult position to argue that traditional contract law doctrines do not apply to premarital agreements. And in fact, we're not really taking issue with Rock and some of these out-of-state cases, which we read to be waiver and or abandonment doctrines, not commingling, not extraordinary circumstances, but just basically you waived your right under the contract.
I think you're saying then that the traditional contract doctrines can apply, but just not the equitable doctrines that apply in divorce cases.
Exactly.
That's
right.
the line?
That's the line that we're drawing. And part of the reason is because we don't read the act to to do away with those longstanding contract law doctrines, but we do read the act to say when the agreement results in this kind of inequity, then you can step in and correct it, to be essentially a preclusion or foreclosing courts from stepping in on other equitable grounds.
And wouldn't it be, just thinking very globally, I mean, a prenup that says my separate property is my separate property going forward, you could always have a result where one spouse, because of their prior separate property, has many more assets than the other spouse, right? I mean, it seems that could be a common occurrence.
I at the very least, it's not uncommon.
Right,
And
it
I
would-
think this
yeah.
court's precedent suggests that it happens regularly, that the fact that I have a generous
It's often
parent,
the driving thing behind the prenup, right? It's often the very thing. that
right,
precipitates
it's
it.
often that, right, the reason behind that. But I think it's not uncommon that you would have an inequitable, to use that term loosely, but one spouse receives more in the divorce than the other because of a prenup, because of inheritance, because of these doctrines that we apply. And the courts in Utah do not typically rely on that outcome as a basis to do away with the prenup or to apply extraordinary circumstances. And
But doesn't that put, I mean, both of these are divorce law, are divorce statutes, and then are the Uniform Premarital Agreement Act.
right.
Doesn't that put those two statutory schemes at odds with each other?
I really don't think so. And do I wish in the Premarital Agreement Act they were maybe a little bit more express? I do. But I think the way to reconcile them, at least one way, is the general specific canon. And you can look at the 81-4 and say, okay, this applies when people just get divorced, right? And you don't have a premarital agreement at issue or whatever else. But to have them say in the immediately preceding chapter, you can agree on anything you want, essentially, besides child support, and that will be enforceable unless you committed fraud or lied about your assets or whatever else. And so to me, it's really hard to read those side by side and not see the legislature saying, when it comes to premarital agreements, the other equitable doctrines, they're no longer part of the picture.
It just doesn't seem right, but I take your argument.
Thank you. I
All
appreciate
right,
it.
we have certainly kept you over your time, so we'll give you your full
Thank you,
amount
Your
in
Honor.
rebuttal. Ms. Adams.
Thank you, Your Honors. Let's go ahead and start there. It really doesn't seem right, does it? It's really important that the UPPA does not reference the equitable doctrines at all. It's also very telling that when the UPPA was enacted, that we had very robust common law about these equitable doctrines applying, and there wasn't any conflict preemption or field preemption in the language of the UPPA. All the UPPA does is say, hey, you guys can enter into contracts on a wide variety of issues.
Well, let me ask you my same question then. If it's not uncommon, I mean, the reason you enter a premarital agreement is because you have assets to protect. You have premarital assets that are separate property. And it seems that it would be a not uncommon circumstance that because of that, at the end of a divorce, you are going to have an inequitable result. So is it your position then that in every one of those cases, the district court can, basically ignore the premarital agreement because the end result isn't equitable as would be considered in divorce statutes?
No, Your Honor, that's not our position. I think that it's very clear in this law that in Utah, that if you have separate property and you have substantial separate property coming into the marriage and you don't do anything that would make that separate property marital through commingling or contribution, then you can walk away from that marriage with substantial
But
separate property.
what work is the prenup doing then? Because if what you're saying, and this to me is the dividing point between the two briefs' positions on this question. If what you're saying is that separate property is separate and marital property is marital, and then we're even with a prenup, the separate property is still going to be subject to a commingling analysis or an extraordinary circumstances analysis, then what is it that the prenup has changed?
I have two answers for you.
Yeah.
So the first answer is that when you essentially have two questions when you're looking at divorce property. The first question is this separate or marital? And then the second question is, if it's separate, do any of the equitable doctrines apply? This prenup answers the first question, but it doesn't answer the second question because it doesn't have any terms. And so I think that, yes, could you have a prenup that goes and talks about contribution and commingling? Very possibly. But you have to look at not the broad parameters of the statute, but what the prenup actually says.
But there wouldn't
this
have been-
prenup doesn't say anything.
But there wouldn't have been any question about whether his fidelity account in 1996 was separate property. I mean, they get married in 1996. He's got a separate bank account. Everybody knows what's in the separate bank account. So they don't need a prenup to say that that's separate. It's already separate. And so I'm back to my question, which is what work is a prenup doing in the legal framework that you're giving us?
It makes it separate. I think it just takes away that whole first question off the table. So that instead of, if there is a divorce, you don't have to go through and determine when was this established, blah, 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 blah. Yes, you're right. Under the law, it would have been separate anyway. But sometimes there are questions that arise and people try to go back and get that property even though there hasn't been any equitable provision. So I think it's just it's a just in case document to make sure that we're setting up the marriage, that we know what property is separate and what property isn't at the time of the marriage. What's important, Judge Tenney, is that this agreement itself doesn't mention anything about the equitable doctrines. I think if we had an agreement that did, we'd be in a very different land.
And what would it need to say? That they don't apply?
It would need to have
Or that they
broader-
do? Or, something about it?
Yeah, so it would need to say, it would need to say that they don't apply, or it would need to at least reference them in a pretty straightforward way. Whenever
So could you say in the agreement then that commingling, we basically are opting out of commingling, that no assets could be commingled in the future? Like, this is a separate account and no matter what happens, it's always going to be separate, and commingling just isn't available in the event of a divorce? Do you think parties could contract to that and a court would have to respect that? Or is that something that the equitable principles of the court would override?
Right. I think that is something that they could contract to, but the question is, of course, there could be questions about conscionability or something. Like if, for example, Travis Kelce and Taylor Swift get married and they have these types of provisions in their contract, everyone's gonna be like, these guys are worth millions and millions. Where it doesn't matter if their money's going to go together. They're going if they get divorced, they're going to walk away with hundreds of millions of dollars. We don't really care about whether the money was commingled or not. But if you have perhaps a different situation, I could see that being a problem. And we do have all this case law that does allow district courts to apply equitable principles. But notably here, Your Honor, like we have very strong case law about waiver of statutory rights, and the equitable principles are statutory rights. And it says under Utah law, waiver of a statutory right must be clear and unmistakable in contracts and courts.
Okay, so let's talk about this contract. We're circling
Yes.
back to the language of the contract. I'm looking at paragraph 1, which is
Yes.
the provision about what we're going to do with the separate property that's included in Schedule A.
Yep.
And in the middle of that paragraph, once it lays out, that we're talking about separate property, it says that the separate property is going to be, quote, free from any claim, demand, community property rights, or statutory interest of the other, which might have arisen in any way because of the marriage of the parties. I mean, the answer that you gave a minute ago was, well, in theory, they could waive claim to the equitable rights, but here we're exempting any claim, community property rights, statutory interest that might have arisen in any way. Why isn't that clear enough to say that what they were doing was saying this is going to remain separate, period?
Right. So I think the key language here is because of the marriage of the parties. So any interest which may have arisen in any way because of the marriage of the parties. And here, when it comes to commingling and contribution, those circumstances aren't occurring because of the marriage of the parties. Yes, the parties do have to be married to have those circumstances occur. But for commingling, especially, marital money has to be going in and out of the separate property accounts. And so the equitable principles such as commingling are not affected because of the marriage of the party. They're affected because of the party's actions after the marriage.
Well, and there is that factual sort of scenario here, right? Money went both ways from this account. I mean, money went to pay taxes and to supplement when there wasn't enough of Ellie's income to cover the household expenses, right? And then certain monies went to the account during the marriage, right?
Right.
I mean, it went both ways, right?
It went both ways, but it wasn't like a doll circumstance where we have a loan coming from separate property and then the marital income repaying the loan.
Mm-mm.
We have just this is just a stash. This account is just a stash of marital property and separate property, and it's all mixed up there together. And let me just point this court to pages 485 to 499 of the record, exhibits 17 through 37. Those are the exhibits. That's the record where Ellie walks through with Peter all of the checks and all of the commingling that has occurred in this account. Now, notably, the parties were married in 1996. They got a bunch of documents from this Fidelity 100 account, but it wasn't a complete document haul from the account. There were some documents missing, so they didn't have anything from the early 90s except for maybe the initial documents. They had some in the early 2000s and then some in the 2010s. But what we found is that there's basically 4 sources of commingled income. First, you have $25,000 of his income.
Let me
from-
actually stop you there. You agree that Judge Stone didn't find there was commingling, though, right?
So it's a little bit complicated, Your Honor, because if you look at page 437 of the record, the court says, first, there was substantial evidence of commingling, and that's relevant. Second, Ellie contributed to all of this, to all the household essentials, and then was able to allow him to build a separate asset. So that's paragraph 10
Right.
on page 437. The way that the court, I think there are arguments both ways. The way the court drafts it, clear that the court is thinking about commingling and the court's thinking about exceptional circumstances. I think regardless of how this court views this this provision, you can still rule in Ellie's favor because we have alternative grounds for affirmance. If you just flip that order a few pages forward, if you look at paragraphs 19, I think it starts on 19 to 28, or excuse me, 22 to 28, so paragraphs 430 to 432 of the record, we have
You're flipping
8
backwards.
Yes,
Okay.
backwards. I apologize. Backwards. The court makes substantial findings about the commingling that happened. In paragraph 22, the court makes a finding that Peter put all of his earnings into his censor earnings.
So
into the document.
here's maybe a tricky procedural question.
Yes.
Judge Stormont takes over this case, and he rules in the Rule 59, Rule 60 motion context that Judge Stone didn't find commingling, but that Judge Stone rather used that relevance of commingling to find the extraordinary circumstances. Isn't that the law of the case that we're dealing with now? Because it's the district court in this case has made that determination, clarified to the extent there was any confusion or lack of clarity in the original order that in fact commingling was not found. And you do argue it as an alternative basis in your brief, right? That we can alternatively find that the account was commingled.
Yes, I think it does. Judge Stormont's order does give us problems, but certainly I think on alternative grounds we're solid, because at no point does Peter challenge any of these findings in Judge Stone's original order. All these findings from 22 to 28 that Peter commingled his income and all of these marital funds.
Right. I don't take from the brief, and Mr. Morrison can correct me if I'm wrong, that he was contesting that those particular deposits were made in the Fidelity account from marital funds. I think there's an explanation of his consulting fees being sort of put in the wrong account and ending up in the 401k that does get divided. And as I understood his brief, that the amounts that were truly marital should be subtracted out and then divided. So I don't necessarily think there's a difference there. But it's a little bit difficult on appeal. I think if the finding below is that there was not commingling, then as the appellant, you don't have to challenge the findings, right? Because the finding wasn't that it was commingled. Am I misunderstanding the argument there?
I mean, I think that it's pretty. I mean, I think it's still pretty mushy because he has all of these. The Judge Stone has all these findings about commingling, and then says commingling first. First, there's commingling, and that's relevant. And Judge Stormont, I think, tries to wrestle with that and figure out what is Judge Stone actually saying. But let me just note, Judge Oliver, when we look at commingling, I think it's really important to look at those pages of the record, 485 to 499 and Exhibit 17 through 37, because we do have that $25,000 of censor income. And the court found that although Peter said that he deposited it into a marital account, there were no documents to show that he did that. And then we have...
Right, but we don't... A lot of divorce cases have no documents. I mean, a lot of cases have no documents, right? And testimony is valid evidence. And we say this all the times in a lot of contexts, civil, criminal, family law, that testimony on the stand under oath is sufficient evidence, right? So I take your point that he didn't have the checks or the documents to demonstrate it, but that doesn't just by itself mean that it's an insubstantial basis, right, to demonstrate the fact.
Right. I agree with you, Your Honor. In addition to that $25,000, we also have $75,000, and that's Exhibits 29 to 37 of all sorts of marital income that went in and out of that went into that account: cashier's checks, checks for trailers, checks for cars, insurance payments. We also have, I think there was about $129,000 that Peter said were gifts from his parents, but there was also some evidence that these could have been reimbursements for vacations. And then on top of that, if we look at Exhibit H, it's his Social Security statement and he's made $270,000 over the course of his life. And the court, and although most of this money was made prior to 2005, the court said, well, we don't know if it was asked to him during the trial, did you put this in your Fidelity 100 account? And he's like, well, I mean, I probably put it in the joint account, but I don't know. Right? It was pretty unclear where that money ended up.
Let me ask a question, turning gears just a little bit to the more question on the extraordinary circumstances, because we certainly have a lot of situations where in a couple that's divorcing, one member was the primary breadwinner, right, and the other one was not, right, maybe having sporadic income over the course of the marriage, very limited income, and if that's all that it takes to be extraordinary circumstances, it's not extraordinary. So I'm trying to understand what particular circumstance in this case made Ellie's contribution entitle her to a distribution of inequity of the Fidelity account. Or am I misunderstanding it and it's really Peter's actions of the commingling that created the plus factor or the more for the extraordinary circumstances? Or maybe it's both.
Your Honor, I think it's both. I think we have the plus factor of Peter commingling a bunch of marital assets, and so they weren't put into the marital estate, and also the fact that Ellie did work full-time. She took the full responsibility of the kids and work. And so Peter actually described himself in court as a quote-unquote professional bum. And so I think given all those circumstances together, the court determined that there was the contribution exception applied. I will note really quickly, Your Honor, that it seems to be, we've been talking about, we know the money that went in, or at least we know some of the money that went in. So why can't Ellie just pull it out? Why can't we just pull out this $100,000? The problem is it's not clearly traceable. We don't have records. And we know that some money went in, but of course we have all this money from his Social Security income that's reported on a Social
Why
Security
wouldn't it be
statement.
traceable? I've struggled with this concept every time
Why
I've sat on a
isn't it
commingling
traceable?
case,
I know.
which is not, I haven't sat on a ton of them, but at some point it seems like it's a math problem. There's an input and there's an output, and then there's a, you can figure out the rate of return, you can figure out the interest. I'm not sure why it's not traceable as
It's
a math
not-
problem.
Yeah, it can be traceable, Your Honor, in that if they had an expert that went and did the math, and there are lots of family law cases where they have experts that can come in and they do the math.
Yeah.
And they say, look, they inputted, they put this much money in, this much interest accrued, this is how much their portion is. Because here, like, it wasn't that she put this money in, she'd also be entitled to the interest that accrued on the premarital property that was put in. That's very confusing.
But it's not his burden to show that. Isn't it Ellie's burden? She's the one trying to prove that it's separate property or not separate property.
Right, so she carried her burden by putting on evidence of all of these checks and deposits that were put into the account that were separate property. And then if Peter wanted to rebut that, he needed to put on an expert, say, no, this wasn't separate property, or else, this is what she is owed. Nobody put on any expert testimony to try to, they call the metaphor they used was to unscramble the eggs.
Right.
Because you have all this money that's fungible that's dumped into an account, and all this money is going in and out, and nobody traced that. So we know that Ellie had, there were certain marital expenses that were deposited into the account, but we have absolutely no idea how much interest those deposits are. And doing some math, if you have $300,000, if there's a 9% interest rate, which is what Peter said, he assumed a 9% interest rate over 24 years, you get to $2.4 million. So it's very possible that that they could have reached this $2.4 million amount.
Even without the inheritance.
Yeah, and the
trying to
inheritance is not very clear, Your Honor. I mean, I know that it says we have a distribution from the mom's trust of $93,000, and then we have $30,000 of a gift from parents, but we don't seem to have, at least I'm not recalling.
Where's the 1.5 coming from? Because I thought it came out in the briefing. I thought the assertion in the briefing was that 1.5 of the 2.4 came from the inheritance.
Your Honor, I'm not recalling that off the top of my head, but I will definitely look and do a 24J letter. But anyway, that's all to say is that a small amount of money with the beauty of interest can accrue into something quite large. And it simply would not be, if we do truly have commingling here, which we do, then it doesn't make sense to do what Peter is asking, which is to just pull out those discrete deposits that were made over the course of 20 years, especially because, number one, we don't know all the deposits that were made. We know that Peter made a lot more income than was actually deposited than the checks that we had in 2010, 2011. And we don't know where that money went. And also, we wouldn't be able to calculate the amount of interest that would have accrued on each one of those deposits.
I know we're out of time, and I'm gonna do the unfair thing and take you back analytically to the first question. And I know we're a few questions past the first question, but I
You're
wanted to make sure I got
for full circle mode today.
like full circle mode. I wanted to make sure I got your answer to this question because it's the thing that's bothering me about this first issue. So just to frame it up, to sort of let you get your brain reoriented. The initial question from the briefing, as I understand it, is whether in the face of the Uniform Premarital Agreement Act, the equitable doctrines such as commingling or extraordinary circumstances can even touch property that's in the prenup, right? And the point that they made in I can't remember if it was the opening brief or the reply brief that resonated with me is that you've got this statute. It's one of the statutes involved in the Premarital Agreement Act, but it's 81-3-205. It's the enforcement statute. You know this is coming. But the enforcement statute says a premarital agreement is not enforceable under the following circumstances, and it gives us three of them, right? Number one, it wasn't voluntary. Number two, there wasn't disclosure. And number three, you're going to leave somebody on public assistance. And it feels to me, I mean, you mentioned this phrase in passing earlier that there's something of a preemption thing floating around here. And just to be candid with you, that resonates with me that this feels a lot like preemption. If the legislature comes in and says, here's the nature and structure of these agreements, and here's how they can be enforceable, and then it gives us a statute and it says, here's the three circumstances under which they're not enforceable. It feels like your argument is coming in and saying, yeah, but there's a fourth. And the fourth is all this equitable stuff. And that feels a little funny to me, that we would write an opinion saying that the legislature has told us that they're not enforceable in three circumstances, but the courts are going to come in and add another one. Well, give me a response to that, because that's bugging me.
Right, right. So we're not trying to say that the premarital agreement isn't enforceable here. We're saying that there's certain provisions where equitable circumstances should apply, where the equitable consideration.
And they
should
would
apply.
make it not enforceable.
And yeah, they would technically make it non-enforceable.
I mean, that's the whole point.
Well,
right?
isn't there a scenario where you agree that section 1 is enforceable as to the original amount of the fidelity account and perhaps the interest income that accrued from that amount all covered in one, and that then everything else is somehow after acquired or commingled? I mean, isn't there a scenario under which you can have both be true if you carve out the value at the time of the marriage and the premarital agreement?
I mean, are you talking about severability, Your Honor? Like, you can certainly sever parts of the premarital agreement that aren't.
Well, I'm just saying
enforceable and still enforce it.
you could still make your argument that the prenuptial agreement is enforceable, but your argument, I think, would be it's very limited in what piece is enforceable, and it's the piece that was in the account at the moment the premarital agreement was signed, and the income derived from that amount under provision 1.
Right. Well,
I don't know.
I can answer, maybe I can answer both these questions at the same time. So it looks like for me, when you look at conflict preemption and field preemption, so conflict preemption is, of course, there's a provision in the statute that directly conflicts with common law or directly conflicts with something else. We don't have conflict preemption here. So the question is, do we have field preemption?
Right.
We don't have field preemption here, Your Honor, because if you look at those exceptions or those three things that make it unenforceable, those all have to do with what the parties did at the time they signed the agreement. So it's all about, like, is there fraud? Are they properly disclosing their assets? Like, that's what it is. It's all about what are the parties doing at the time the agreement is signed, and we're looking at those actions. So when we're looking at field preemption, the Premarital Agreement Act is more concerned about the parties' actions at the time it was signed, whereas when we look at the equitable exceptions, that's all stuff that happens during the course of the marriage. So I don't know if this answers your question, Judge Oliver, sufficiently, but to your question, Judge Tenney, I think that is a very I think that's I'll say it's a brilliant way of distinguishing these things. You could say that the Premarital Agreement Act is all about what happens at the time it's signed, and the equitable exceptions are all about what happens after the marriage. So we don't have field preemption here, because certainly the Premarital
Saying the
Agreement Act
legislature is just
doesn't look
silent
forward.
about the after conduct.
Yeah, I mean, it's not something that I think that the legislature needed to worry about, because if you turn a couple of chapters over to the divorce code, all of the divorce code allows the court to get into the actions that happen after the marriage. So the UPA is all about what happens before. It's not worried about what's
But doesn't
happened
that
after.
completely undermine our notion that contracts are enforceable and we uphold valid contracts? We as judges don't undermine maybe a bad deal. Isn't that basically what you're asking us to do here?
No, Your Honor. So I completely agree that we do not undermine bad contracts. And I think that the question is, what does the contract actually say? And like I pointed to earlier, that when we have a statutory right or some common law that we're contracting around, we have to be very clear that we are contracting around that statute, or we're contracting around that common law right. So whenever there's, for example, in Medley, which is a 2004 case from this court, you have to have either an explicit reference to a statute or a clear reference to the concept that the statute embodies. And if we look at the contract here, we don't have either of those things in this contract. So we've been having this pretty high level discussion about whether the Uniform Premarital Agreement Act can even, whether those equitable principles can even apply to that act. I think this court, although it might want to engage in that analysis, could probably skip it and go right to this agreement and say, if I look at the language of this particular agreement, do we actually have waiver? Do we actually have an abandonment, like a knowing waiver of these equitable principles? And the answer to that, I believe, is no. Like, there's no mention of those
She
things.
signed an agreement that says each party acknowledges that the other shall have full and unrestricted rights to their property, free from any claim, demand, community property rights, or statutory interest of the other, which might have arisen in any way because of the marriage of the parties.
But like,
Isn't that a waiver of
no,
for her?
not for her, Your Honor. I think that I believe applies. Like I said, it's about the marriage of the parties. So
Right, but isn't
right
the
to-
only reason she would get any equity because of the marriage and because it's a divorce proceeding? I mean, that seems to me that the whole basis of her claim is an equitable claim based on the divorce statute.
No, Your Honor. The only reason she gets money is not because of the marriage. Like she couldn't walk in and say, "I'm married. I get his Fidelity 100 account." Maybe in California or these community property states, you could. The only reason she's able to get a part of that account is because of Peter's actions during the marriage, and so it's not, Your Honor, that
But if they weren't married, she wouldn't have that ability. If they were just partners and they weren't legally married, all she could claim was like unjust enrichment and ask for return of the funds. She'd have no equitable claim. The only source of her equitable claim is because of their marriage.
so it's the marriage is certainly the reason why she can even get there. But Your Honor, unless she can't walk in because of the marriage and say, "I'm married, I get his account," which is how I read this paragraph 1. She can't say, "I'm married, I get his account."
You're placing a lot of work on that phrase because of the marriage of the parties.
Because of the
And I
marriage.
think you're saying that if we swapped out the word marriage for actions, that's the pivot point, right?
Or, Your Honor, if you were to say, and I think that you would need to be very clear that you were getting rid of these common law doctrines, that any commingling, contribution, or extraordinary circumstances.
Either
will
by
not apply.
contract or by statute.
By contract or by statute. Yes, Your Honor.
All right, we have kept you
you
long
way
over.
over.
Thank you for answering our questions. It's very much appreciated. Mr. Moritzen, your 3 minutes.
The panel's been very patient. I'll try and limit myself to a few quick points.
Or very aggressive. I'm not sure if it's patience or the opposite.
A beautiful
Sorry.
combination of patience and
Right.
aggression, yeah. So I'll maybe start where we finished up. I think paragraph 1 is unequivocally a waiver. And Judge Oliver made the point, but these equitable doctrines only arise because of the marriage. And so the but-for relationship between a marriage and entitlement to relief based on commingling or equitable distribution or extraordinary circumstances or whatever other equitable doctrine might arise has to fall under the language of paragraph 1. Oakwood also tells us that you can't apply equitable doctrines, even if you're applying equitable doctrines, you can't apply them to override or contradict the plain terms of the party's contract. And that's exactly what Ellie is asking the court to do here. Let me go back to the start of the argument. When we're talking about the failure to mention equitable doctrines, that's where we have a real, I think, issue here, is because if we agree to this and you say you can have this free of any claim from me, that should end the inquiry, and especially with the overlay of the statute. The only thing I'll say about the statute is not all of that is time of the marriage stuff. Whether you're eligible for public assistance based on a spousal support provision is a determination that can only be made at the time of the marriage, depending on the language of the spousal support provision.
But even under that provision, this goes back to Ms. Adams' point about it. That's sub 2 from that statute. It's talking about the provision from the agreement, and it's saying if because of the provision of the agreement, the spouse is then placed on public assistance. So it's still hinging on stuff that happens at the time of the agreement, right?
Well, I think it pertains to the nature of the contract. Like, these are the circumstances under which you can override the provisions of the contract. This is when you can declare it unenforceable. I mean,
So your point is that there is field preemption here, just full stop.
well, I don't know if it's field preemption. I think it is, except for the contract law doctrines. But
Doesn't your argument have to be that it would be field preemption? Because if it's not field preemption, then the equitable doctrines are still kicking around, right?
well, my only point is neither side argued field or conflict preemption in the briefs.
Yeah.
What we argued was expressio unius, which is some version of preemption. But the
It's got
point,
shades of it, yeah.
yeah, but the point is that that's focused on equity. These are the circumstances under which you can apply equity to override the terms of the contract. It's not saying we're doing away with waiver. We're doing away with unconscionability. We're doing away with those. So I wouldn't draw the post hoc, whatever the Latin term is for before and after line. I would draw the equity versus substantive doctrines line. And it's clear that they had equity in mind, and we're telling courts these are the limited equitable circumstances under which you can award relief, and it's a direct quote, notwithstanding the terms of the agreement. And as you put it, Judge Tenney, what they're asking is, well, here's a fourth equitable reason or a fifth equitable reason. I did want to talk just briefly about commingling. I see my time is up.
We're certainly happy to entertain a short.
So on the commingling front, I would encourage the court to review the testimony in the exhibits, which we think we make a very persuasive showing that very few of those were actually marital income. And with that, we'd ask the court to reverse and remand. Thank you, Your Honors.
All right, thank you both so much. We appreciate the excellent arguments and briefing that we received in this case. We will take it under advisement and issue a decision as soon as we are able to do so. We have gone long this morning for our 11 o'clock, so I think we'll just plan to stay here at the bench and let counsel gather their things and get situated for our second argument.